Welcome back. Welcome back. Welcome back. Welcome back. Nah, shit, my bad, y'all. I'm still setting up. That's the first time I tried to do that. But I know the trial was coming up, and I know I wanted to air both of them, so I had to get it done. You know what I'm talking about? They still ain't started yet anyway, so appreciate y'all coming in. Hit the like button on your way in. Tap in, share with a friend. Setting everything up. So you got some time if you need to get your zooms and whams, take care of your business. We right here and we be here as soon as they get started. Appreciate y'all being here. Let's see if he gonna take the plea today. Last we left off, he was talking about the judge was trying to get him to take a plea, cancel out them 5 life sentences plus 70 something years and trade it in for a 16-year plea. Family, what you think? Is Melly gonna take the plea? Let me start a poll. Let me start a poll in the chat. Bortlen. Will Bortlen take the plea? Did I say Melly? Will YNW Bortlen take the plea? All right, the poll is in the chat. Let's see if I could grab some clips while they delayed. They always delayed anyway, so we'll go ahead and grab some clips and see what we can do while they getting ready, family. Appreciate y'all being here once again. Much love, much love. We just ended with the Stop Cop City, Rico. Stop Cop City. And it seems like they lost. It seemed like they losing. He said he did not find a reason for the attorney general to bring a RICO against these people. He said it was an unnecessary RICO. Let me see. Do anybody else got this? Can y'all hear my phone in the back? Let me cut that down. Y'all hit that like button, hit that subscribe. Let me see. See what else we got while we waiting on them. Matter of fact, I know what to do.
More developments in the double murder case of rapper YNW Melly. A new face will represent the state to prosecute the South Florida rapper's upcoming case earlier this year. The trial of 3 men who were later convicted of murdering another Florida rapper, XXS Tentacion. Michael Boatwright, Dedrick Williams, and Trayvon Newsom were each handed life sentences in April for gunning 3 men who were later convicted. Prosecution team that's no stranger to trying high-profile cases. Alexandra Buckaloo state to prosecute the South Florida rapper's upcoming retrial. Assistant State Attorney Alexandra Buckaloo will now take the role of lead prosecutor that successfully tried a case earlier this year. The trial of 3 men who were later convicted of murdering another Florida rapper, XXS Tentacion. Michael Boatwright, Dedrick Williams, and Trayvon Newsom were each handed life sentences in April for gunning down XXX Tentacion in June of 2018. Buckaloo's new role comes after prosecutor Christine Bradley was recused of her role as lead prosecutor after it was revealed she didn't share information with Melly's defense team about a claim against lead investigator Mark Moretti. The bombshell and for Christine Bradley, X Tentacion, and Trayvon Newsom, other Florida rapper, XXS Tentacion. Michael Boatwright, Dedrick Williams, and Trayvon Newsom were each handed life sentences in April for gunning down XXX Tentacion in June of 2018. Buckaloo's new role comes after prosecutor Christine Bradley was recused of her role as lead prosecutor after it was revealed she didn't share information with Melly's defense team about a claim against lead investigator Mark Moretti. The bombshell claims came out in court last week with Assistant State Attorney Michelle Boudreaux and Christine Bradley herself taking the stand to testify about the claim. So what was the claim? It stemmed from a 2022 incident involving Detective Mark Moretti seizing the phone of Melly's mother. According to Michelle Boudreaux, who witnessed the incident, Moretti asked a deputy to lie about being present during the execution of the search warrant.
Did you say anything to Moretti? No, I don't say anything to Moretti. I leave the room, I'm done with the statement. As far as I'm concerned, I'm done investigating this case.
Why?
Because I don't work with detectives that solicit lies.
So, is that true that Detective Moretti said to you that what he said was a joke?
No, what was intended to be conveyed was that Deputy Gorell, his response was flippant in nature. That was the joking aspect of it.
Okay, so there's somebody from your office sends out a Brady notice in this case, not authorized by you, correct?
That is correct.
And in that Brady notice that I just showed you, you're saying that there are incorrect statements of fact in it.
That is correct.
And the incorrect statement is that you were not told by Moretti that he was joking.
That is correct. The indication has always been, and if it was inartfully conveyed in some point, the indication has always been that Deputy Gorell responded in a very flippant manner when asked about showing up.
Flippant manner to whom?
To Detective Moretti.
Does he say that in his court report, Gorell?
I don't believe so.
Okay. So the flippant matter came from Moretti, and somehow you communicated that Moretti said it was a joke. Is that what we're putting together?
I did not say that Moretti said that he had made a joke in any way, shape, or form.
So you've never made the statement that Moretti said he was joking?
My statement was, at all times, and if it was ever not clear or misinterpreted by whoever was listening to it, was that Deputy Gorell made the statement that was of a flippant nature.
Melly's defense team did not find out about the incident until nearly 2 months after Judge Murphy declared a mistrial in Melly's first trial. Judge Murphy later ruled that Bradley be removed from the case out of an abundance of caution, as the defense plans to call her as a witness in the upcoming retrial. Now Buckaloo will be taking the helm. After taking on the new position, Buckaloo asked Judge Murphy for an extension to early 2024, citing that Bradley had been on the case for years.
Myself and the co-counsel on this case, we just got this case 48 hours ago, and we know nothing. And in order to appropriately represent the state, and we'll still get a disadvantage, because Ms. Bradley had been 65 years, she's lived it. We will still get a disadvantage. So if Your Honor's not willing to bring them back in January, at least give us till December to at least get up to speed on the case.
But the judge decided the trial will push through, with the plan to begin questioning potential jurors in the retrial nearly 3 days after Buckaloo and new counsel took over the case. Rapper YNW Melly, whose real name is Jamel Dimmons, faces a possible death sentence if convicted of murdering his childhood friends and music collaborators, Anthony Williams, a.k.a. YNW Sack Chaser, and Christopher Thomas Jr., a.k.a. YNW Juvie. The two were killed after leaving a recording studio session back in October 2018. The state claims Melly is the trigger man, and the rapper used co-defendant YNW BORTLEN, whose real name is Cortlen Henry, to stage the killings as a drive-by shooting. Melly has remained behind bars since his 2019 arrest, even after his first trial ended in a mistrial. Meanwhile, YNW BORTLEN, who previously was out on bond, got locked up just 2 weeks ago on allegations of witness tampering. After Melly's mistrial was declared, his defense team did not waive his right to a speedy trial, which runs out this Friday, October 20th. This means the state and their new prosecutor.
You know why else this don't make sense? You know why else it wouldn't make sense for this to happen? Because he had that bag, family. It's no reason for him to be out there up close and personal shooting people that he could very easily set up. When he had that bag, he could have paid somebody $20,000, $30,000 easily to do that. Like, why would he do it right there up close and personal? That don't make no sense. I don't think I'm feeling it. That's crazy. He been in jail since 2019, had a mistrial. Prosecutors removed for having Brady evidence, got thrown off the case after the mistrial, and they still going. They didn't even find out it was Brady until after the mistrial. That's crazy. And then now he got a new lawyers though. I guess that's good. He got new lawyers because
now to an
ain't no telling how much better, how different it would be with having good lawyers.
update. Rapper YNW Melly is changing lawyers amid his murder case that is scheduled for retrial in 2027. The reason is because someone on his legal team is also under criminal investigation by these same prosecutors which he says is a conflict of interest. He is replacing them with a well-known hip-hop criminal defense attorney who previously represented Cardi B and Lil Nas X. Melly is charged with 2 counts of first-degree murder in connection with murders of his 2 childhood friends. His first trial on the murder charges ended with a hung jury in 2023. He faces the death penalty if convicted.
The next message from Gino to the 9807 phone number.
In this message, Gino states, we here for you, bro. Just let us know what you need.
Who's winning the YNW Melly murder trial so far?
DNA. There's no gunshot residue on his hands. There's nothing showing YNW Melly. The prosecution is missing any physical evidence tying YNW Melly to the murder itself. There's no DNA. There's no gunshot residue on his hands. There's nothing showing that YNW Melly was the shooter. And as far as this timeline is concerned, the prosecution doesn't know when the shooting happened. YNW Melly could have very well been out of the car at the time that the shooting occurred. So for all of those reasons, there are questions, and each of those questions is a reason to doubt.
No, I don't say anything to Moretti. I leave the room, I'm done with the statement. As far as I'm concerned, I'm done investigating this case.
Oh, bad, I'm talking on mute. I'm just getting it together. They got the stream coming up, but they not live yet. So we'll know as soon as they start. It's open, but they not streaming yet. So I got the volume on. We'll hear them as soon as they get started. So that's what I was clearing up. Let me find some more clips while they setting up. You know what I'm talking about? I don't know why I keep saying that. You know what I'm talking about?
How are you today?
Not good.
Are you cold? Here today.
Yes.
You don't want to be here.
Yeah, you're not going to.
Read this statement multiple times.
I looked at it and I just didn't call it and I don't know.
And so you indicated you hoped you were to.
Shout out the flesh of the gods. Tell everybody. Well, I still fighting through the devils, man. Like they be trying their best to hold me back, but y'all gotta give the people what they want, bro. You know what I mean? The people want some real, man. It's time for the real people who ain't pretending to be in position.
Truthful with law enforcement.
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection asked and answered. Excuse me. Hold on.
And in terms of your appearance here today,
Yes.
you don't want to be here.
Yeah, you're not going to. You made me come here.
I did.
Yes, you did.
And in terms of you were served with a subpoena.
Never served me.
And so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
Yes.
did you quit your job?
I got fired because you put me in jail.
And prior to that,
Yes.
before your job,
Yes.
did you quit your job?
I got fired because you put me in jail.
And
Come to find
prior
out,
to
I'm getting locked up for the same charge I just did.
before you were put in jail, did you quit your job?
No.
Okay. So you never quit your job?
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay. So you left your job?
Yes.
Yeah.
And come to find out, I'm getting locked up for the same charge I just did 96 months for.
Pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions. with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial.
Now, to summarize that, they are
The original copies as well that were provided.
Counsel does not have the
and allowed this trial to go on. Okay, now when we talk about not the smoothest of moments, so they asked as a professional.
Yes, that's exactly.
Thank you. So can you make copies for those?
I printed, I found all of them. If there's one that she's missing, I'm happy to do so, pull them up again. I printed them all this morning for her.
Counsel's suggesting she doesn't have them, so I just want to make sure she has them.
Of course, and that's not a problem. So, but they've all been turned over via email. This is all in there. The original copies as well that were provided.
Counsel does not have the ability to print something out in the courtroom now. She's asking counsel, Ms. Raven, is asking for a copy of it. Let's provide her a copy.
I'm happy to do so. I just need to know exactly which one she says she's missing and which one she says she has. I don't want to have to duplicate them if possible.
None of the documents she's published says testimony started.
Give me a courtesy, just print all of them out.
Okay.
All right?
Can we take a break while the jury's on?
We can. But can we finish this first?
Oh, yes. I thought you were finished.
You're gonna make copies of all the documents.
So she has in her hand some of them already. So I just want to make sure I don't double print them
Just double print.
on that. So
Counsel's suggesting she doesn't have them. So let's just print them all.
Okay, well, she does have some of them. Just want to make sure.
For the record,
Listen, I don't know, you're saying they're sent, counsel's suggesting she hasn't received those things. I just want her to get copies of it. I don't want your constant back and forth. Well, she has it, just give her the copies. That's it. It's easy. Just get her the copies.
Seems like it should be pretty straightforward, right? Just print some documents for the opposing side. Violation. This is a big no-no to the defense. Well, Judge Murphy agreed that the prosecution, they weren't acting very fairly.
And that seems to me to be a Richardson violation. There's a discovery that's ongoing. You know about it, and you're not telling them about it until we're here in court. So as far as the already is concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. I just think the only way it can be cured is he's not going to testify about this second procedure that happened. That's not coming in. Same thing. If you want to keep investigating a case, you can do it. You can find exculpatory information. You may change your mind as to how you proceed with the case, and I don't have a problem. You can investigate whatever you want to investigate. But as far as
what up, Rhonda Hall? I see you. Appreciate you joining, family. Keisha E in the building, Allie in the building, no one in the building. What up? What up? Appreciate y'all being here.
Using new discovery that you're coming in, I think a cutoff needs to be happened because this is what's going on. We're going to have this. If you find something new, there's a whole, as counsel describes it, that then you try to find evidence to plug up the hole. That's new discovery. The defense doesn't have an opportunity to depose the witness. The defense doesn't have an opportunity to do X, Y, and Z. And that's just not the way it should be. It shouldn't be done by surprise. So
it's clear this was not a new item. This was just this. All of the information was told to be identical.
You found it. You did.
Wait a minute. Hold on, family. Y'all said 50% of y'all said. Hold on. Let me come up. 50% of y'all say that he will take a plea. 50% of y'all say he will take a plea. 38% say no. 12% say maybe so. Dang, y'all feel that type of way? Y'all think he gonna cop out and take the plea? Oh no. That 16 do sound a little different than them 5 lives. That do sound a little different. All right, let's get back into it. I just had to trip off that. Y'all said 50% said yes, he gonna take a plea. That's crazy.
Shout out to Flesh of the Gods. Tell everybody. Well.
Oops, wrong one.
You had a meeting with the detective in May when we're in hiatus because I'm on vacation. All right? Got a meeting with him in May after we picked a jury. and when we're ready to, or we're in the middle of jury selection, you picked it, you did it, and you said, well, he tells you, or you ask him, do you have more, programs to go ahead and provide the information, and you find out there's another program, and he runs the program, does a different download with something other than Cellbrite, and therefore, you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple weeks of trial testimony, and then when it comes up after he, in cross-examination, points something out, you bring it up and say, well, by the way, I told him, the detective in our pretrial meeting, it came up and he has the program and we can use it and we're doing it, all right? And, but you don't tell him about it. You just go ahead and hold it, keep it close to the vest yourself. Don't explain it to him, and then you say, when it comes up at trial, I say, what was it? I don't have the report yet, and that's why I didn't turn it over to him, but didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation. Okay? So, as far as the Detective Moretti, and whatever other form he used, that's not coming in.
Okay.
All right? That's the sanction. If you have other information, other discovery that's in the works, you better share it with them, because right now, if you don't have it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because, you find out they have additional capabilities and you want to go retest something, that's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to him. If you didn't turn it over to him, you can't use it. That's really the basic.
Understood.
So that's a win by the defense there, that the prosecution can't use that.
That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedent's name as the identifier. It's in the name of Jamie King, not Jamel Demons. It was retrieved from Jameson Francois, not Jamel Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that, definitively. It shows the phone being used to call.
Miss D56, what up, though? I see you. Appreciate you joining, family.
Shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else.
Where is the phone located?
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
Then they have to establish it before they put it in, not after the fact. This Instagram account is being used and accessible to a
You went back to Melly's house.
This notion that, it's his account.
Got into yes or no? She
yes.
She can't check that time. How'd you get in?
The door is unlocked.
Were you aware whether or not Melly had a contractual agreement to do a video shoot that day?
Yeah, it was something like that. I know he probably would have lost a lot of money if he didn't go to the music video. He was upset.
Was Melly crying at Frito Bank's house?
Yes.
Were you crying?
Yes.
Because you all grew up together.
Mm-hmm.
Then Assistant State Attorney Christine Bradley cross-examined Adrian Davis.
Mr. Davis, you said you're 100% sure that Mr. Dennis found out at the same time you did?
Yes.
No questions about that? You're sure he was at that house?
Yes.
Christine Brady Bradley.
And you were upstairs?
Yes, ma'am.
He was downstairs?
Yes.
But you're sure he was there, you could see him?
Mm-hmm.
Is that a yes?
Yes.
And you are 100% sure his phone was missing?
Yes.
Where in the statement on May 5th did you ever say that?
Objection.
Suggestion.
It was never asked.
Thank you. Counsel, so I guess the objection is improper impeachment, so rephrase your question. That's just the
So,
objection.
you met with me on May 5th, 2022, do you remember that?
Yes.
And you remember sitting down, you were present? That's a yes?
Yes.
Your two attorneys were present that you brought? That's a yes?
Yes.
And I asked you questions for quite a number of hours. Do you remember that?
Yes.
Okay. And do you remember being asked if you had met with anyone else with regards to this case?
Yes.
Okay. And do you remember being asked if you had met prior to speaking with me with the attorney sitting over to my left?
Yes.
Okay.
I didn't know who they were. And
She also asked Davis about Melly's cell phone.
So on the phone on that, do you remember if Mr. Devins had a passcode on his cell phone back then?
I don't think so.
You don't think so? And in terms of, would you be surprised to find that there was one on that cell phone?
No.
Did you know the passcode?
I don't think so. I don't remember if he had one. We all use this phone sometimes. We all use each other's phones.
So you would use his cell phone? Why?
Talk to females.
You pretend to be him to get women? Because you couldn't get them on your own?
Objection.
Why would you use his phone then?
Let me rule before you ask the next question. All right? It's overruled. Go ahead, answer your question. I asked you.
Well, at this time, Your Honor, the state would move what has been already provided to Your Honor.
Let me go back on there.
He's already got it. Label it there.
All right, let me go back on the record. This is State versus Cortlen Henry, 19-1871 CF10A and 23-10643 CF10A. I continue to have Ms. Collins, Mr. Griffiths present for the state, Mr. Haddad present for Mr. Henry, who continues to be present. State, yes.
As a formality, state would move at this point what has been provided to Your Honor previously in reference to State's Exhibit 1. It's the two cuts that Your Honor already talked about for audio files that the state already discussed, that Your Honor reviewed by stipulation of the parties.
Device, as that's charged, the second-degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state device, as that's charged, the second-degree felony, the maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null process or drop counts 1 and 2, both first-degree murder charges. Okay. And in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months, 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you could subtract that from the 100
I think
and...
he actually has more time on the 23 case than the 19 case out of custody.
Oh, okay. Well, whichever case you have more time, less time.
What y'all think, family? He gonna take that plea deal? I don't know. That life after life after life after life sound a lot different than 16, don't it? But if they offering those two wide range of differences, it tells you there's some monkey shit going on. That's a fact.
Monkey shit.
We still waiting on them to go live. We're still playing in the back. So as soon as they go live, we'll be there. We're just running over some of the evidence from the last trial.
2 or 3 of them.
Okay, so what you can do is identify them by the clothing that they're wearing.
Jewelry, black jacket in the left, sack in the middle, jean jacket, tay, black jacket.
And Sack is he standing or sitting?
Sitting.
And Tay, is he standing or sitting?
Sitting.
And you said Cortlen was wearing the black jacket. Is he standing or sitting?
Who?
Oh, how did you refer to him? My apologies.
Tay.
No.
Or Julie.
The person wearing the black jacket, who did you identify that as?
Julie wearing black jacket. Also, is Tay wearing black jacket.
The person wearing the black jacket who's standing up, do you recognize that individual?
Chris.
Okay. Do you recognize the people in photograph image 3?
Same one you just showed. Same person.
And who's that person?
Yeah.
The 3 images that were just shown from State 72, do you recall when those photographs were taken?
Same night.
Would that be, what date would that be?
10/26.
Of 2018?
Yeah.
What location were those photographs taken in?
New Era Promotions studio.
Was that the studio we just discussed that you guys were hanging out at?
Yeah.
I'm now publishing State 7. Publishing 10/26/2018, beginning at timestamp 2/17/42. Mr. Glass, you recognize the 2 individuals in this screen pause at 2/17/47.
I recognize the back of the head.
Yes, you recognize them.
I just see the back of the head.
Okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52?
Still back of the head.
Do you see an individual standing next to a red vehicle?
Yeah, that's cool.
Okay, you just said that's who?
Cool.
All right. And what is Kobe's real name?
That's what I know about Kobe.
All right. Would anything refresh your recollection as to his legal name?
I don't know.
If I were to show you your prior statement, would that refresh your recollection?
Good.
Permission to approach the witness?
Right.
Has your memory been refreshed as to the legal name of Kobe?
Yeah.
And what is Kobe's legal name?
Objection.
What's the objection?
Sorry, I was
Jacoby Mills.
Okay. I'm sorry.
Jacoby
And if you could repeat the last name for the court provisional.
Mills.
All right, I'm going to continue to publish State 7.
There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual?
Not really, no.
Okay. How about the individual that is standing at the gray Jeep?
That's set.
Okay. And then continue to publish. I'm pausing at timestamp 2:18:21. Do you see that individual who's walking away from the Mitsubishi Jeep?
I see him there.
Do you recognize him?
That's AD.
Okay. And again, I'm going to ask you for AD's legal name.
The absence of evidence is not I know his last name, David.
Okay. Would looking at your statement refresh your recollection as to his legal name?
I guess so.
Honor permission to approach.
Can I have the same statement?
Yes, Judge. Approaching the witness. Mr. Glass, same procedure. If you could take a look at that and look up.
We are no.
Oh snaps, we got I Show Speed in the house. What up, Speedy Clips? I just see the back of their heads. Appreciate you joining, family.
Without speaking, has your memory been refreshed as to AD's legal name?
Yes.
Okay, what is AD's legal name?
Adrian Davis.
Continuing to publish, date 7. Mr. Glass, let me know if I need to rewind the video, but you had a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts?
Me.
Okay. Continuing to publish. I'm pausing the video at 2:18:41. You see that individual carrying something across his shoulder, wearing what appears to be a blue jacket.
I know that ain't Speedy.
Do you see that person on the video?
I see the back of his head.
Do you see the back of the head of the person wearing the jeans jacket?
Correct.
Was that person the same person that you previously identified in state?
Stay, rephrase it.
Okay. We previously looked in state 72 at an individual you identified as Melly.
Objection, Your
Stay.
Honor.
One moment. Publishing state 72.
Ask and answer, Your Honor.
There's no question pending.
What's your question? Do you see the jacket in states 72, image number 3, the front of that jacket?
Yeah.
Okay. You see that jacket in states image 1 of state 72.
I see the same thing y'all see.
We spoke about this, Mr. Glass.
I'm standing that way.
You ask questions, right?
I'm asking questions, Mr. Glass, and I'm just asking you to respond if you have knowledge. Is that jacket that was in image number 1 and image number 3 the jacket that Melly was wearing on October 26th of 2018?
To the best of my knowledge,
To the best of your knowledge, yes or no?
yes.
Publishing states 7. And then go.
To the best of my knowledge. Yeah, that's what I said.
Okay. Back to state 7, timestamp 2/18/41. The individual that's on
I don't
screen
recall none of that. All I recall is going back to prison.
wearing a jacket and it appears to be something across his back. Who is that individual?
Objection, ask and answer.
Overruled.
Mr. Glass, you can respond.
I see the same person as last time.
Okay, and can you tell us who that same person is?
Melly.
Continuing to publish.
Ask a question, y'all know the answers to.
Mr. Glass, you can't speak when there's not a question. Mr. Glass, do you see that individual carrying something in their left hand? I'm asking if you see them, just if you see them. Do you recognize that person? Okay, and who is that person?
Bishop Thomas.
Mr. Glass, can you identify for the record, and I know there's a video, but can you identify which vehicle you got into?
Red Mitsubishi.
And can you tell us who was in that car with you?
Kobe, Tay, and 80.
So 80, Tay, and Cody. Is that a yes?
Yes.
So that is a total of 4 people.
Correct.
And in the vehicle to the left of the screen, the Jeep, who entered that vehicle to your knowledge?
Everybody else that was there. Zach, Melly, Julie, Cortlen.
Okay. And by my count, is that also 4 people?
Correct.
Right? And when those, okay. Continue to publish at 2/19/36. I'm going to stop at 2/19/46. At the time you left the studio in that red Mitsubishi, where were you headed?
Supposed to be home.
Okay, and who's home?
It's Melly house.
Okay, and was everybody in that red car headed to Melly's house?
To the best of my knowledge.
Okay, and what about the Jeep? Where was your understanding that that Jeep was headed? The gray Jeep?
Same spot.
So both cars left the studio with the intention of heading to what you identify as Melly's house.
Correct.
Can you tell us, I guess, what was the mood or the vibe at the studio while you guys were there?
It's 5 years ago. I can't tell you nothing right now.
Okay, if you don't recall, that's fine. Was there any physical confrontation that you observed at the studio?
Looks like a regular day. Studio, smoke and drink.
Right. And you just mentioned smoking. What were you smoking, specifically you?
Weed.
Okay. All right, and now the vehicles, we saw that the gray vehicle on the video pulled off first. Can you tell us where you guys, the route you guys took to the best of your knowledge?
I can't tell you because I don't know.
Okay. Do you recall getting on a highway at all?
I recall being in the car while I was driving. I don't know where. I don't know. I don't.
Okay. Were you awake the entire time you were in that vehicle?
I wasn't.
Okay. Do you know at what point you fell asleep?
I don't.
All right. And when you left the studio, you were awake. Is that a fair statement?
I was.
And at what point do you recall waking up, or what time do you recall the next thing you saw?
Once we came to a stop.
All right. And where did you come to a stop?
At the house gate.
And the house gate for Melly's house.
Yeah.
When you got to the house gate at Melly's house, who was inside your vehicle, the red Mitsubishi?
Same people you've seen get in the car.
All right. So by your testimony, Kobe, AD, Tay, and yourself.
Yes.
Okay. So still 4 people.
Still 4 people.
Do you recall how you guys entered the gate?
The gate was open for us.
And publishing states 47. I'm going to pause it at timestamp 3:49, it looks like 58. Do you recognize that red Jeep? Mitsubishi?
I do.
Is that the vehicle that you left the studio in?
Yes.
And is this the guard gate you just testified to at Melly's house?
Yes.
Okay. And do you see that screenshot at timestamp 3:51:31?
Mm-hmm.
Is that yes?
Yes.
Okay. Do you see yourself inside that red Mitsubishi vehicle?
Yes.
And where are you located? Okay.
Keisha in the building. What up, family? We here. We still waiting. They super late today. I don't know what's going on. They definitely on Glanville time. This way past that 30-minute delay that they be talking about. But appreciate you being here. Shout out to you. Let's keep it rolling.
And do you recall going through the gate, going through the procedure of going through the gate?
Yes.
So you get through the gate. Where do you go next?
To the house.
All right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house?
Yeah.
Okay. Are there any other cars parked?
There go YNW Melly and King Von. If y'all know about King Von from the Young Dirk situation.
In that driveway when you get to the house?
No.
All right. Do you see the gray Jeep that you left the studio with at the house?
No.
All right. So what do you do when you get out of the vehicle?
From what I remember, I went upstairs and went to sleep.
Okay. And you said upstairs. So the house is how many stories?
Couple.
Okay. So you went upstairs to where specifically to sleep?
In Julie's room.
All right. Was Juby in his room?
Nah.
Okay. Do you recall where Melly's room was?
Hold on, I see them, family. They moving. They ain't got no sound yet, but they moving. Let me move this stuff off the screen. I see movement. We got action. Let me move this up off the screen real quick. Oh wait, this one, yep. Ain't no sound, but we got some movement, family. Man, I keep doing that.
Shout out the flesh of the gods. Tell everybody. Well, I still fight through the devils, man. Like they be trying their best to hold me back, but y'all gotta give the people what they want, bro. You know what I mean? The people want some real, man. It's time for the real people who ain't pretending to be in position.
Was in the house.
Not upstairs.
Okay. Do you recall where?
I turned. We turned it back. Okay, my mic is on. I thought it was off. But yeah, I turned it back on so we could hear them. But we'll hear it as soon as they start. I keep that on the screen.
Was if it was not upstairs.
I think it was like first room as soon as you come in the house.
Okay. Was Melly at the house when you got there, from what you can recall?
No.
Did you see Melly at any time in the house?
No.
Right. So you go upstairs in Juby's room, and what do?
Crash.
All right. Crash meaning?
Go to sleep.
Okay. At some point, do you wake up?
Yeah.
And why? Or
Phone
how?
calls, phone calls.
Okay. Safe to say that your phone was getting a lot of phone calls, blowing up.
Yeah.
All right. And at some point, you answer the phone, correct?
Yeah.
Okay. What do you do in response to the phone calls?
I answered the one that kept ringing, and yeah.
All right. And so what do you do in response to getting that phone call?
I ended up at the hospital.
All right. Do you recall which hospital that was?
No, I don't.
Do you recall what city you were in at this point?
I was in Broward.
Right. What city? Not the county.
Miramar.
Okay. Do you know if you went to Miramar Hospital?
I don't know what hospital it was.
Okay. So you get to the hospital. What do you find out when you get to the hospital?
That Anthony and Christopher was deceased.
Okay. And obviously at that, well, let me not say obviously, but at that point in time, what do you do? Or how do you react to that news?
Grieving.
Okay. Do you stay at the hospital?
Not long.
Right. Where do you go after the hospital?
I ended up somewhere. Somebody's house.
All right. Do you recall whose house that was?
I don't know whose house it was, but I ended up there.
All right. Let's start with the city. Do you recall what city that house was in?
Miramar.
All right. Do you recall if it was in the same or different area than where Melly's house was?
It looked similar.
We got 57 votes and only 15 likes. Come on, family. Y'all get them likes up as y'all coming in. Y'all hitting the your opinion. Hit the like button too. It's all right. It ain't gonna hurt you.
Okay. And just to clarify, was it the same or different house than Melly's house?
Different.
Okay. Where did you go when you went to that house?
What you mean?
Like, where in the house did you go? So you go to the house. Where do you go?
I went inside the house. I was in the back.
Okay. And would your statement reflect your recollection as to whose house you were at? Your Honor, permission to approach. I'm going to show defense counsel the same statement. Page 4. Same procedure, Mr. Glass, if you could just review page 4.
See nothing about the house.
If you could just read the entire page, and when you're done, let me know. Page 62.
Yeah, I do.
Okay? Who are those individuals?
Melly and another dude, Fredo.
Okay? You said Melly and another dude, Frito?
Yeah.
Do you know Frito's name and or any nicknames?
That's all I know about him.
Frito? Do you recall ever going to Frito's house?
Just that time.
And just that time being what time?
After I left the hospital.
Okay. So this. And for the record, what is Frito wearing in the photograph?
Shirt. White shirt.
Okay. So after the hospital, you went to Frito's house.
To the best of my knowledge.
Okay. And what were you doing at the house?
Still grieving.
Okay. Who took you to the hospital?
The cameraman.
Okay, do you recall his name?
Drew.
Right. And do you recall who took you from the hospital to Frito's house?
Same person.
All right. And before you left for the hospital, or actually, who went to the hospital with you and Drew?
Just Drew.
Okay. Who was at the house, Melly's house, before you left for the hospital?
Same people that was there when we got there.
Okay, and same people being the 4 people that entered the Mitsubishi?
Yes.
Okay. So you're at Frito's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were?
Drew was wrong.
No, not Melly's house. Frito's house. Where were you in Frito's house?
Outside.
Okay. And who was at Frito's house when you first got there?
Everybody that wasn't at the house.
Okay. And it's because I don't know who everybody was or is, can you please specify?
Kobe, Melly. I'm on people I can remember.
Okay. Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new day. Nah, he wasn't.
Nah, he wasn't. You guys
wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
It's not the evidence of absence.
What?
Yo, shout out to Allie for the gifted membership. Look like they almost ready to start, family. They not quite there yet. They getting there though. Shout out to Allie for dropping the gifted membership before they get started. Y'all hit that like button, hit that subscribe. Let's keep it going. They about to hit that mic button soon, I'm sure, family. I'm sure of it. But other than that, appreciate y'all being here. Shout out to everybody in the chat. Chan My Black is golden. Keisha E, Trakisha, Allie, Speedy Clips, I Show Speed. That's I Show Speed, y'all. We got I Show Speed in the house. Now, shout out to y'all being here for being here. TSC, much love. Our stream sponsors. Let's keep it rolling. Uh-oh, sound like some mic coming.
Okay, let me go back on the record. This is on the top of my page 5, State versus Cortlen Henry, 19-1871 CF10A and 23 10643 CF10A. I've got Ms. Collins, Mr. Griffiths present for the state. I've got Mr. Haddad, Mr. Nascimento present for Mr. Henry, who likewise is present. So I had set this afternoon for the deadline as to whether or not Mr. Henry wanted to accept the state's offer or not. Since we're set to go with jury selection tomorrow morning, so Mr. Haddad or Mr. Nascimento will go forward with a change of plea this afternoon. And state, is it the same terms that you discussed previously? Is there anything different?
No, Your Honor, that has changed. It's correctly reflected on the plea forms.
So the pre-forms to me look like on the 19 case as to the 2 counts of accessory after the fact, as well as to all 4 counts in the 23 case. These are going to be adjudications, 10 years Florida State Prison, followed by, that's a 6 years probation.
That's correct.
6 years probation. All counts will run concurrently, all sentences run concurrently with one another. And it looks like there's no restitution in the 23 case. In the 19 case, I'm reserving restitution and ordering it payable. That's going to be to Terry Bagley as well as Ashley Phillips.
Yes, sir.
So we now have to
We've spoken to them and they don't anticipate there being any restitution, just because caution.
Okay. Well, I'll give you 120 days to tell me an amount. If there's
Yes,
no
Your
amount, you won't give me restitution.
They are present as well, too, so our victim advocate has informed them that
Okay.
there's any restitution, they can let us know.
Okay.
As of today, they said there is none.
All right, and state, is that the complete terms? That's it?
He's also going to be giving it proffer, Your Honor, at a later time.
Well, is that part of the negotiated
Yes, Your Honor.
resolution?
It is.
So tell me how that works. Sure.
Logistically,
Sure, come on up. Madam Clerk, this is not on.
Man, it's got to be the most sidebar in this trial we have ever seen. They can't go 5 seconds without a sidebar. Jeez. They can't go for 5 seconds.
The absence of evidence is not the evidence of absence.
What?
Shoot, H-Town said 10-year plea deal. Shoot, he get offered that 10-year, he for sure gonna take it. They put 10 on the table, he for sure gonna take it. Whether they did it or not. Just cause how the evidence is looking. And it ain't even like they got evidence, they just got people that's saying they did it, so that's crazy. They be out of control with these sidebars. Let's see, we're gonna keep on going with where we was at with the previous stuff while they on the side. We got some stuff we could play while they there. Where old boy go? Here you go. Y'all hit that like, hit that subscribe. Let's keep it going.
And
wait, never mind. Oh, okay. I thought they was coming back. Never mind.
how long do you stay at Frito Bank's house?
I don't know.
Right? Minutes, hours, days?
Could be minutes, could be hours.
Okay. So not days.
Not even a day.
Okay. And so when you got to Frito's house, was it light or dark outside?
It's light.
And you previously said yourself and Melly and someone else was at Frito's house. Was Frito there as well?
I think I did see him. I don't remember.
Okay. What happens while you're there? Like you're there, you're outside, what happens?
Greeting.
Okay. And you're grieving.
They moving, but no sound. They moving. No sound yet. Okay.
Are you grieving alone?
Yes.
Are you at the house at any point in time? Do more people come to the house, or do people leave the house?
If they did.
Shoot, he talking to him though. Why they don't got the sound on?
Presently under the influence of any drugs, medication, or alcohol, please let me know. I'll try to ask you a better question, okay? As loud as you can so the court reporter can get down all the answers, okay? Raise your right hand for me. You swear to tell the truth, whole truth, nothing but the truth? You can put your hand down. Please state your full name. How old are you? How far did you go in school?
Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? How are you feeling this afternoon? Your head is clear? You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question in your mind whether he understands what's going on?
Nothing at all. No, yeah.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State Prison. Counts 3 and 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State Prison. In case number 23-10643 CF10A, you're charged in count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. And count 7, unlawful use of a 2-way communication device. As charged, that's a second degree felony. The maximum penalty is 15 years in Florida State Prison. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct? Yes. And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process that has dropped the 2 first-degree murder counts. All right, I'm going to adjudicate you guilty. Yes, sir. What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a 2-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State, you're going to null process count 2 and count 5.
No.
As it relates only to Mr. Henry.
No.
So, Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a 2-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a 2-way communication device, that's a second-degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's the second as charged, I believe. It's a third.
But y'all got me here for the murder. Why would you accept that?
Third, except as it relates to a capital case. But I'm happy to look it up. Well, what did you want the negotiated sentence to be for that?
That was just going to be the maximum time served.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so, sir, as to that count, it's going to be an adjudication of 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount.
Hey, am I tripping, y'all? Did I mishear that? Or did they bring it down to 5 years? Did they just say that, or am I tripping?
I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record, and it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you've negotiated is the deal you've negotiated, and that's the ballgame. Do you understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've answered all your questions? You're sure that that's what you want to do? Because I want to emphasize accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation in the unlawful use of a two-way communication.
We got to run it back. We got to run it
What's
back.
happening with that?
It's D56. We got to run it back.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State, you're going to null process count 2 and count 5.
Correct, Your Honor.
As it relates only to Mr. Henry.
Correct.
Okay. So Mr. Henry, what it's going to be is 2 counts of
But they going to try to null process the murders, though. That's crazy. And
accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation in the unlawful use of a two-way communication device. That's a second-degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's a second as charged, I believe. It's a third, except as it relates to a capital case. But I'm happy to look it up.
Has it as a third, that's what we discussed, so.
Well, what did you want the negotiated sentence to be for that?
That
5 years? Is that what you want me to do?
correct, Your Honor.
Okay. All right, so sir, as to that count, it's going to be an adjudication of 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose.
But they already been in jail. He already been in jail 5 years. So that means he would be getting out if he take this plea. What up, Lil Dom?
Mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record, and it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you've negotiated is the deal you've negotiated, and that's the ballgame. Do you understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've answered all your questions? You're sure that that's what you want to do? Because I want to emphasize, Mr. Henry, and I'm going to do this again at the end of my plea colloquy, whether you resolve the case by way of a negotiated plea or an open plea to me, or you resolve the case by way of a trial, it doesn't matter to me at all. But due to the resources that have been devoted to this case, I have 250 jurors summoned for jury duty starting tomorrow. So I want to be very thorough with you here this afternoon, because if you wake up tomorrow or the next day and you decide you've changed your mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. All right? If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words, because I've given you plenty of time to think about this, talk to your lawyers about it, talk to your family about it. I talked to you about it last week. Kind of looks like your lawyers probably did something or other to get a better disposition for you as of this afternoon, but this is it today. So understanding all that, you've had enough time to talk to your lawyers about all that, that's what you want to do? So, sir, has anyone forced you, threatened you, or coerced you into entering these pleas? If I accept your pleas, there will not be a trial in either one of these cases. Do you understand? If I accept these pleas, there's a whole bunch of constitutional rights you are giving up. I want to make sure you understand all of those rights. You have the right to maintain your plea of not guilty and have a trial in each case. You have the right to present defenses, to file motions and other pleadings in support of your defense. You have the right to remain silent. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to confront and cross-examine the witnesses against you. You have the right to appeal any decisions that I may have made up to this point or any rulings I might make in a future trial. But understanding by entering this negotiated resolution today, you are giving up all of those rights. The matter is going to be resolved today, right now, this afternoon. Is that what you want to do? Are you satisfied with your lawyers? Have you had enough time to speak with them? Have they answered all your questions? Are you satisfied with all the work that they have done for you? Sir, I've got two identical plea forms here entitled Plea of Guilty or No Contest to Criminal Charges in Circuit Court. Each one has your name on the top, your initials on the left-hand side, front and back, and your signature on the back. Did you go over both of these forms? Any questions about what's on either of these forms? And is that your signature on the back of each form? Sir, there's a few things that I need to tell everyone that I take a plea from. They may or may not apply to you. If you are not a citizen of the United States, these pleas will result in your deportation. Do you understand that? Under the provisions of the Jimmy Rice Act, if the offenses to which you are pleading are sexually violent or sexually motivated offenses, or if you've been previously convicted of such offenses, then these pleas will subject you to an involuntary civil commitment as a sexually violent predator upon completion of your sentences. Do you understand that? If these are the drug offenses, the Department of Motor Vehicles will revoke your driver's license for a period of 1 year. Do you understand that? Sir, paragraph 11 of each form that you sign reads as follows. I acknowledge that my attorney and I have reviewed any discovery disclosed by the state. My attorney and I are unaware of any physical evidence for which DNA may exonerate me. In other words, sir, if there's any physical evidence in the case that we could test for DNA, that DNA evidence would not tell me that you were not one of the people in that vehicle when these crimes occurred. But actually the opposite would be true. If there was any such physical evidence that could be tested for DNA, that DNA evidence would tell me that you were one of the two people that was inside this vehicle when these crimes occurred. Sir, do you agree with that statement? State, do you agree with that statement?
Yes, Your Honor.
Defense, do you agree with that statement? Mr. Henry, understanding everything that I have talked to you about up to this point, do you still want to go ahead and resolve both cases today, right now? Defense, is he stipulating to a factual basis for the purpose of each plea in both cases?
Yes.
And if he's entitled to a PSI, defense, are you going to waive that as to each case?
Absolutely.
State, is there anything else that you need me to do before I take his plea?
No, Your Honor.
Okay. So, Mr. Henry, again, two cases. We're going to do one at a time. In case number 19, 1871 CF10A, as to count 3, accessory after the fact to murder in the first degree, and as to count 4, accessory after the fact as to murder in the first degree. How are you going to plead, sir? Guilty, not guilty, or no contest? In case number 23, 10643 CF10A, as to count 1, tampering with a witness in a capital felony, and count 7, unlawful use of a two-way communication device. How are you going to plead, sir? Guilty, not guilty, or no contest? I will accept your no contest pleas as to each. I'm going to find a factual basis to support each based upon my review of each electronic probable cause affidavit as well as your stipulation in court here today. I'm going to further find that you have freely, voluntarily, and intelligently waived your rights, that you have knowingly entered each plea with the advice of competent counsel who you've told me that you are satisfied with, that you understand the nature of the charges and the consequences of the plea. Accordingly, and pursuant to the negotiated agreement, I will sentence you as follows. In case number 19, 1871 CF10A, as to count 3 and count 4, I will adjudicate you guilty, sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. I will impose mandatory court costs. Pursuant to 943.325, I will need a set of your prints and DNA. Pursuant to 938.27, I will impose a cost of prosecution of $100. Sir, I'm also ordering restitution in that case payable to
Terry, Terri Bagley, Bagley, and Ashley, Ashley Phillips, Phillips, and reserving as to the amount. I'm going to give the state 120 days to tell me the amount of the restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. That will conclude that matter. In case number 23-10643 CF10A, as to count 1 and count 7, I will adjudicate you guilty. Count 7 is a sentence of 5 years in Florida State Prison. Count 1 is a sentence of 10 years in Florida State Prison, followed by 6 years of reporting probation. I will impose mandatory court costs in that case as well. I will not impose the cost of prosecution in that case as I just did so in the previous case. Pursuant to 943.325, I will need another set of your prints and DNA. All of these, there is no restitution in that case. All of these sentences, all counts, both cases, will run concurrently, that is at the same time with each other. I will give you credit for all the time that you have served. State, in 19-1871 CF10A, your announcement as to counts 1 and 2.
The state will be announcing a null process to those counts, Your Honor.
And in case number 23-10643 CF10A, state your announcement as to count 2 and count 5.
The state will be announcing a null process to those counts as well.
Okay. I think that concludes all the matters. State, is there anything else that you need me to do regarding Mr. Henry in either case?
Mr. If you just have one moment.
Phillips, Phillips, and reserving as to the amount. I'm going to give the state 120 days to tell me the amount of the restitution. If they fail to do so within 120 days, the state RI also order 8.27 and DNA pursuant to 938.27. I will impose a cost of prosecution of $100. Sir, I'm also ordering restitution in that case payable to Terry, Terri Bagley, Bagley, and Ashley, Ashley Phillips, Phillips, and reserving as to the amount. I'm going to give the state 120 days to tell me the amount of the restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. That will conclude that matter. In case number 23-10643 CF10A, as to count 1 and count 7, I will adjudicate you guilty. Count 7 is a sentence of 5 years in Florida State Prison. Count 1 is a sentence of 10 years in Florida State Prison, followed by 6 years of reporting probation. I will impose mandatory court costs in that case as well. I will not impose the cost of prosecution in that case as I just did so in the previous case. Pursuant to 943.325, I will need another set of your prints and DNA. All of these, there is no restitution in that case. All of these sentences, all counts, both cases, will run concurrently, that is at the same time with each other. I will give you credit for all the time that you have served. State, in 19-1871
So he getting out.
CF10A, your announcement as to counts 1 and 2.
The state will be announcing a null process to those counts, Your Honor.
And in case number 23-10643 CF10A, state your announcement as to count 2 and count 5.
The state will be announcing a null process to those counts as well.
Okay. I think that concludes all the matters. State, is there anything else that you need me to do regarding Mr. Henry in either case?
Mr. If you just have one moment.
So he getting out. He already he getting time served. He already did all that time. That's what they balanced it back out to. That's crazy. And you know,
I'm looking at the plea forms. The 23 case, they have 707 days credit for time served. In the 19 case, 1,340 days credit for time served.
They was talking about 16 years. They cut that down. I said even if they offered 10, he'd take the 10. I knew he was gonna take that, but that's crazy because by doing that, they got him to agree to conspiracy after the fact. I mean, you know what I'm saying?
So listen, the fee hearing docket is at 3:30 p.m. So
We've already spoken with BSI. I think we're just in an order. It's here for about a week.
okay. I mean, I was going to make it available if you wanted to do it now.
I think BSI has problems with that.
Okay. Well, they're in charge.
Just coordinated with us, right?
Yeah, of course.
Judge.
Anything else from the defense on behalf of Mr. Henry?
No.
All right, Mr. Henry, I'm not quite sure how your lawyers managed to do this, but I wish you good luck, sir. Yeah, he'll be on Mr. Nascimento, Mr. Haddad. We'll have a probation, but all right, Mr. Henry, I'm not quite sure how your lawyers managed to do this, but I wish you good luck, sir.
He said, I'm not sure how you always manage to do this. how you get out on this. Because the state, that's why these prosecutors are full of shit. That's crazy.
Yeah, he'll be on Mr. Nascimento, Mr. Haddad. We'll have a probation officer here tomorrow. He'll be on my docket tomorrow morning for the instructions on probation. So I will sign all the paperwork if you want to stick around for that. We're otherwise going to be in recess till 3:30 p.m. The fee hearing docket starts at 3:30 p.m., so I'll be in a recess until then.
They gonna do a pre-hearing docket today? It's almost 3:30 that time right now, ain't it? That boy said, I'm going home, forget that. He ain't actually snitched yet, but he did take that plea deal. This the same one Young Thug and everybody been talking about. Look at him, he's smiling. Look, I'm coming home. He said, I got time served. He been in there, what, 5-6 years already? Hell no. So is he gonna take the stand against Melly? That's the question. Is he gonna take the stand against Melly? Shout out to our stream sponsors. Show some love real quick to TSC. Look at, hold on. Yeah, we keep it rolling. Look at him, look. Hell nah. He said, I'm going home, forget that. Trikisha said he better go live in Utah. Shoot, Utah ain't no, man, them Utah police jails is crazy. I seen some clips about that. They don't play. I mean, not like crazy like regular prison, but crazy like racist. So he got a total of 16.6 years probation and time served from previous. Yep. If you take the stand, he can't pull a Woody. It won't change his sentence. Facts. I don't recall. 16 years probation. Yeah, I'm sure he'd take that with no problem. Get the Happy Meal ready. He getting up out of there though. He said, forget that. Yeah, see, they're supposed to be starting at 3. What time is it? It's like 12:30. Let's see if they got something scheduled for later. I don't recall. Hit him with the Woody, I don't recall. Shout out to Woody.
Shout out to Flesh of the God. Tell everybody. Well, I still fight through the devils, man. Like they be trying their best to hold me back, but y'all gotta give the people what they want, bro. You know what I mean? The people want some real, man. It's time for the real people who ain't pretending to be in position. Huh? Shout out to Flesh of the God. Tell everybody.
The absence of evidence is not the evidence of absence.
What?
Okay, hold on. Yep, look like we might got some action. Family. Hold on. Oh, is this the same one? Oh no, this is the one we just watched. That's the one we just watched. Hold on. Let me see. Look at. Hold on. Let me rewind that. They just take all his chains off or what? Hold on. Let me rewind. Let me switch strings again. What they doing over there? Oh no, they spraying his hands or something. Hand sanitizer or something. Took the plea, family. Took the plea. So let me see the stats was out of 99 votes, 56% said yes, 34% said no, and 9% said maybe so. Appreciate y'all for y'all participation, family. Took the plea, y'all. What y'all think about it? Y'all think he should have took the plea or no? Y'all think it was a good deal? I think I seen Trakisha say it was a good deal. Or was that Keisha E? I think I seen one of them say it was a good deal. Fingerprints and DNA samples. Do y'all think his attorney will rub his leg for comfort? I think only DK get the leg rubbing attorney. That's what I got. Yeah. Yep, so will he take the stand against Melly? What y'all think, family? Let me see. I'm gonna start a poll while we play some more of this clip we was playing earlier before we wrap it up. Appreciate y'all being here. Don't forget to hit that like button while you're here. Hit that subscribe, tap in, you know what I'm talking about.
Well, isn't this a nice surprise?
You're about to get the email and send it right now. Yeah. Custody movement? Or we'll just leave it for the codefendant? Okay. But everything's off. Thank you. Please tell everyone else thank you very much.
All right, family. Look like that's it for them for today. So I'm gonna go ahead and wrap it up. If they do go back live at 3:30, which would be in 30 minutes, then I'll open it back up. Y'all make sure y'all set y'all notification bells and we'll pop back up. But until then, stay fresh and stay blessed. I got a redirect for y'all. If y'all want to tune in to Cat Not Williams, she's still streaming, so I'll send y'all that way. But I appreciate all y'all being here. Don't forget to hit the like button on your way out. Hit the subscribe. Show some love. Shout out to our stream sponsors, and let me shout out everybody in the chat. Appreciate y'all being here.
The absence of evidence is not the evidence of absence.
What?
Shout out to Miss D56. I appreciate it. I was watching Beyond the Gates and didn't spell it correctly. What up, No One? Appreciate you, family. Let me take off this second screen. I got the double screen up. The double me. No One, Trakisha, appreciate you being here. Chan, my black is golden. Time is an illusion. Better out than in. Spend your time wisely, my friend. Big facts, big facts. What up, Brooklyn? I see you in the building. Shout out, Brooklyn. Trakisha, thanks for covering this. You got it. No problem. Thanks for watching. Appreciate y'all being here. I will continue, like I said, when they come back, and if not, we'll work on something for that a little later. Miss D56, appreciate you. Brooklyn, Lil Don, appreciate you. Tia C, appreciate you. Shout out to everybody. No One, Rock Solid, Watch the Rise. Allie, shout out to Allie, stream sponsor, appreciate you. Speedy Clips, I show speed in the house, appreciate you being here. Shout out to everybody. All right, fam, we out. See y'all over at Cat if y'all going there. It'll redirect you right after this. Much love, much love. Stay fresh and stay blessed, family. Peace out. Don't forget to tell her I sent you. Much love. Go sub up to No One. Go sub up to Rock Solid. Peace out, Keisha E. Appreciate you. Chad My Black is golden. Much love.